Okay, ladies and gentlemen, we'll go ahead and get started. I have 11:02. We do have some copies that are coming on our way for members of the committee, so that way y'all don't have to look all the way back there to see what's going on the slides. From our last meeting, we discussed the Ethics Clarification and Reforms Commission report from March of 2019 and kind of get a deep dive breakdown of that. The purpose of that was to show this is what people have identified as the problems in our ethics laws as they are today. So we kind of know that these people have said there's a problem, that there's an issue. Now it's time to do a little bit more of a deep dive into what the ethics laws are today. And we're going to go into what the Supreme Court and the Court of Criminal Appeals have had to say regarding our ethics laws in Alabama. I will tell you that does include a discussion of Ex parte Hubbard. We are not relitigating that case. This has not to do with the facts of this case, but the Court of Criminal Appeals spent 160 pages discussing that topic. The Supreme Court of Alabama spent 160 pages discussing that topic. We have 320 pages of the appellate courts of Alabama discussing ethics and the issues with ethics laws as they are today, and it would be foolish of us not to at least address and hear and take heed of their advice and what they have to say. So this is not a going back and forth over that case. This is just about the topics and the issues that we have. Members of the committee, we're going to have Jimmy Hintrikin with LSA give us a breakdown of this today. As it was last time, we have members, I believe, that are joined us over Teams through streaming online. We also have any questions that you want to ask at any time. Please just recognize, ask to be identified. We have no problem stopping you no matter what we're doing, because this is important, this is in depth, and this is kind of one of those into the woods of ethics law. So if you guys have any questions at any time, please don't hesitate to stop Mr. Hintrikin and kind of let him know what you think or what your problems are, what your issues are. So with that being said, Mr. Hintrikin, you want to kind of give us a rundown of where we're headed today?
All right, sounds good.
Oh, wait, hold on. Yes, sir, Representative Jackson.
Are we going to acknowledge who's here?
There's no voting. We're not doing anything today, so it's more of a work session. We're not going to take roll. We are going to just get into it and then go through the process.
Okay, thank you.
Yes, sir.
I love it that way.
All right, well, good morning. So I think it was Monday afternoon, I was talking with the chairman about today's meeting and the things we're going to cover, and thought it might be a good idea. Hey, if we jumped straight into the commission report during this last meeting, and we thought it might be a good idea to take a step back for just a couple of quick minutes and give an introduction, just kind of like, well, how does the ethics system work in the state as a whole? So we thought I might give a couple of minutes on that, and then maybe recap some of the topics that we discussed, not in great detail, just a quick summary of the topics we discussed during the commission report before we dive into the case, which accentuated some of these issues. So, which had a great idea at the time. Well, so Monday afternoon and Tuesday afternoon, I put these things together, but now I'm not really sure if I remember everything that I put into this PowerPoint at the beginning about the Hubbard case. So forgive me if it's a little bit kind of all over the place. We'll try to work our way through it and see what we got. Okay, so as we can see here, we're going to start off with the introduction. What we kind of want to cover just very briefly again is, so who is covered, the Ethics Commission, enforcement, and then what are the primary restrictions. And again, this is just the 50,000-foot view of how our ethics laws work in the state. And this is me. I just went through the ethics laws and tried to and gleaned out of this what I could for a very quick summary. So starting off with who's covered by the ethics laws, right? All public officials, elected and appointed at the state and local levels. It might be important to note right here that this includes, of course, you as legislators, but it also includes mayors, councilmen, county commissioners, library board members, board of education members, all sorts of folks at the public elected and appointed official level. It also includes public employees at the state and local levels. So, since I work for you, a lot of times my world revolves around legislators, right, and legislative staff, and even executive branch agencies. But it obviously extends well beyond that. Staff for the legislature, the judicial branch, executive branch employees and all those government agencies. It includes teachers. It includes university employees. It includes city clerks, so other city office employees, police, firefighters, county employees, so just a broad spectrum of public employees. And on top of that, you add family members of those public employees and those public officials. And then you have lobbyists and principals as well. So as the commission report noted here, I got a few asterisks, just a few points to bear in mind. There's over 300,000 public officials and employees in Alabama that are identified in the report, and I think Representative Simpson, Mr. Chair, you mentioned that during the last meeting. And then when you include family members in that, and lobbyists and principals, you get up to, potentially a million or more Alabamians covered by these laws. Another note here that about the enforcement, and I've got another slide on this that goes into a little bit of detail, but not much more. Just a note to make sure I didn't forget that the Ethics Commission and the Attorney General's office and district attorneys both have responsibilities in the enforcement of the ethics laws. Okay, so next step, beyond just who is covered, sometimes questions arise as to what is family members. So it's a little bit different for public officials and public employees, right? So public officials includes a little bit more. Parents, spouses' parents, siblings and their spouses. Public employees, it's just spouse and any dependents, right? So those are what we mean, or what the ethics laws mean when they say family members. So it's a little bit different depending on the context. So now another quick part just about the Ethics Commission itself, right? So it's overseen and interpreted by a 5-member commission that has staff and investigators. I think that's about 14 to 16 staff involved with the commission. It might vary from time to time, but that's the last time I checked. As far as responsibilities, and again, by the way, there's going to be a lot of reading, a lot of words on pages here. So during these slides, I'm going to try to skim over some of this and not read everything that you see on the slide, because there's going to be plenty to come later. So as far as the responsibilities are concerned, we have all these required filings, and I didn't mention everything, right? But you got registration for lobbyist requirements. You have different contracts that public officials or employees engage in that involve public funds. You have opportunities where public employees or officials might be engaging in some type of interaction with a regulatory board or some entity with which you might oversee or not oversee, that kind of thing. So there's all kinds of filings that come into play where the Ethics Commission acts as a repository for. They also conduct training. They investigate potential violations. They issue formal advisory opinions, that covers prospective conduct, right, and provides legal protection if followed. They also issue, at least the staff issues, informal confidential opinions about prospective conduct. It offers less legal protection, but still helpful. They refer determinations of probable violations to the AG's office or the applicable DA's office for any kind of prosecution. They also cover campaign finance, FCPA issues. So there's a lot going on there. As far as enforcement's concerned, like I mentioned before, it's enforced by both the Ethics Commission and the AG's office and district attorneys. The Ethics Commission staff does all the things I just kind of went over, but they don't officially prosecute the cases. I've got a note in here about how they may authoritatively resolve minor violations, and minor violations might not be the right word the right term to be used, but that was just kind of the way I summarized it. That's involved some, relatively smaller fees, but there is a connection to obtain working together and get consent with the AG or the DA. AGs and DAs also maintain independent authority to investigate and prosecute potential violations. So that's kind of a quick portion of the procedural, administrative, enforcement procedures. But what I try to do on this next slide is just kind of cover, like I said, 20,000, 30,000 foot view of what are we talking about in general? Like, what does the tree look like? Not just the branches and leaves. What does the whole tree look like, right? If you kind of take a few steps back. And this is just Jimmy, right? In my opinion, you could kind of summarize, these are the major things. These are the primary things right here. You've got prohibitions against acting under a conflict of interest. We've talked about that, during last meeting, what that means. We've got a gift ban, right? Restrictions on a thing of value between principals and lobbyists and elected officials and public employees and their family members. You've got the use of office for personal gain, the prohibition against that. Section 7 is basically a catch-all, right, for anything that's done with a corrupt intent, right, or for a corrupt purpose. You also have confidential information that's prohibited from being used for personal gain that you obtain while you're in office. That's under Section 8. Converting your campaign or inaugural transitional funds to personal use, that's prohibited. Lobbying of any branch of state government or local government for compensation, sections 1.1 and 23 kind of touch on that. And then there's this 2-year revolving door kind of employment restriction that we talked about also. And then disclosure requirements for statements of economic interest. So those to me were the primary kind of prohibitions and restrictions that are contained in the ethics laws. And as we can kind of see from this going forward, why it ties in a little bit is because the commission's report touched on several of these major issues as we looked at. And then as you'll see the court's opinion from Ex parte Hubbard, they also touch on a lot of the same things. So we thought these things are kind of all connected somewhat. So moving into this next section, now just a quick review of what we talked about last time, the Ethics Clarification and Reform Commission report. Again, these are the 5 areas of focus. I'm not going to go into detail again because you have the PowerPoints. We've talked about that last week, but just as a quick refresher, right? The commission's report talked about the gift ban. They talked about the definition and the scope of principle, conflicts of interest, revolving door, disclosure requirements. So a lot of the same things I just mentioned about the core issues and core restrictions in the ethics laws were touched on, a lot of them. So let's go into these real quick. So just as a quick refresher again. So the gift ban, again, remember that's the 5.1 restriction against soliciting or receiving things of value or offering or providing things of value between public officials and employees and their families, between lobbyists and principals. The thing of value is broadly defined, right? Any gift, favor, or item of unmonetary value, but it has 18 exclusions. Some of the takeaways from that, from the commission report were like, okay, there's a broad definition. It could either be, applied, the scope could be either really large or somewhat narrow, depending on the definition. And there was also no real area of distinction between going over this gift limit by $1 or more, and then violations of using your office for personal gain or some type of corrupt influence. All of these things carry a Class B or felony or a Class A misdemeanor upon conviction. So that was kind of a distinction they noticed. It was worth addressing.
Before we move on through there, as you kind of talked on the broad definition, when you go back to who is covered by the ethics laws, which is on your other slide, this is where we're talking about public employees, not only public employees, but their spouses as well. So we've moved out of elected officials with the gift ban. Now we're talking teachers. We're talking, any city employee or county employee. That's where we get to the 300,000, and then you move their families. We're talking to $1 million on the gift ban issue, correct?
That's exactly right. As you may remember, that term principal, right, is any person or business that employs, hires, or otherwise retains a lobbyist. And some of the notable issues addressed by the commission were, like I said, that broad or narrow scope of the definition of a principal and what that applies to and what we just kind of talked about. The commission report also included a discussion on conflicts of interest. It noted the 2 distinguishable but, separate, similar but distinguishable definitions of conflict of interest that are found in the definition section, and then 1 in a prohibition section. Section 5 has a prohibition for legislators voting under a conflict of interest. Section 9 has another section where any county or local, official or employee can't vote where they have a financial interest involved. So they don't use the term conflict of interest, but there's kind of a loose connection there, and maybe loose is not the right word. There's a connection there. So anyway, as you remember, we touched on that, right? I included the definition pages just yet again in case you hadn't had just to kind of remind ourselves of what the distinction is. I won't go over it now because I think we're going to kind of go over it a little bit later, but suffice it to say that one definition focuses on ownership control of a corporation, of some type of entity, where the other one focuses on the legislative or public official action of some sort, inaction, decisions, but it also includes any business with which the person is associated. And both of them deal with this idea of, are you uniquely affected by this? Is this business uniquely affected? Are you uniquely affected? So both of those are similar in that. Okay, we touched on revolving door. The commission's report touched on the revolving door issues, which again was that 2-year waiting period, right, for for folks leaving public service in some kind of way and going back in front of either representing clients, lobbying, in contracts, just working for them, and then appearing back before your former employer, your former body, your former agency, that kind of thing. Those restrictions, the commission noted that, okay, there might be some ways that we could ease up the potential restrictions that from reading the text. If there's any clarity to be had, it can be had in a couple of areas, right? Public-to-public permissibility should be, most likely increased. Rehiring former employees, remove ambiguous or duplicative language. And this was the slide that I repeated the same line twice. It was funny that I had duplicative language in a phrase saying, don't have any duplicative language. And there's a little bit of vague language in Section 23A, which is connected to some of the issues that are involved in revolving doors. So anyway, what we didn't cover last time was the statements of economic interest. And I'll just kind of briefly mention, right, every state requires some type of, financial disclosure filings that we uncovered. Alabama's, includes, among other things, the name of the individual involved, the household income, real estate investments, a listing of indebtedness. Candidates are also required to file. Some of the things I wanted to mention out of this, though, that was that Senator Orr kind of spearheaded a discussion with the commission about, are there ways that we can kind of remove some overly burdensome requirements and but streamline some other things and delete other things that might be unnecessary or don't necessarily advance the goals of statements of economic interest. Since we didn't have a chance to go over this last time, I want to just briefly say from the commission report, you could see that regarding who must file, there was discussion and movement towards, like, okay, would it be helpful to require specifically and expressly certain members of local boards and commissions to file, ways to streamline the list of appointed officials and supervisory employees within county and municipalities who must file. What about appointed officials at the educational level, K-12 public school levels, boards of trustees, colleges, universities, and what about public employees who award contracts? Regarding what must be disclosed, I won't mention everything, but some of the things about adding new things that might be just kind of go ahead and disclose all investment funds of any type, right? Kind of update the descriptions of how you categorize what your professional services are. Disclosure of all real property, not just homestead. And require disclosure of contingent liabilities in addition to just regular debt. So some of the kind of ideas of ways to streamline things and add things. I won't spend too much more time on that because we got to get to the main focus of today's meeting. So before I move into that, are there any questions? Like I said, that was a very brief overview. I know it was so broad, I probably missed several key elements in there, but I just want to kind of touch on that so that we're kind of, our minds are back involved with what we're dealing with here and what we're kind of looking at. So if there's no questions now, I'll just jump straight on into the next section.
Yes, sir. Thank you, Mr. Chairman. Are we saying that our current policy law now is too much gray, or not enough black and white, or too vague? What's the problem here? That's what I'm trying to get.
Sure. Yeah. So the way I would phrase it is the commission report definitely expressed certain areas of the ethics laws where there's some language that exists that could definitely be revised and clarified to make things a little bit more clear, right? So, not that it might not be clear in the end, but what about the process along the way, right? So yes, the commission report, I'm not going to speak for myself, right? And especially since you guys are the policymakers, right? You get to kind of look at this and decide what things that you think, if anything, should be made clear or not clear. But yes, I think to the intent of your point, of your question, yes, the commission report clearly identified several key areas where some clarification could be used. Sometimes vague, ambiguous, like what does it mean in general, or could it mean more than one thing? So yes is the short answer.
Okay, so it's too much situation ethics rather than black and white. If it's, I'm going to use this terminology since if it feel good, if it's going to help me, then it's all right. But if it's going to help someone else, then it become illegal. That's the interpretation here.
All right, say that part again.
I'm gonna try to help. I think what the point you're trying to hit on is exactly right from the language from the report. And if you look in the ethics laws, there's too much gray area. There's too much that's left up to interpretation and too much that's left up to the discretion, and not a black and white where it's an individual can make the determination. Okay, this is against the law or this is not against the law. There's no clear line that's drawn on a lot of issues.
See, I'm not an attorney, but I know the difference between right and wrong.
Yeah. Well,
and if it's wrong, don't do it. I mean, wrong is wrong, right is right. So there's no right way to do wrong. Go ahead. Do it.
I agree. And what we're about to get into here are some questions that at least the court identified as areas that where there might be some gray, right? Or there might be a distinction in what the language of the statute says and what the intent or the policy of what your position as the policy of the state should be. So it's a good transition. We'll kind of get into it right now.
And that's why you serve on this committee, Representative Jackson. Representative Travis?
Yeah. And I guess the question I have, like that under 3, what must be disclosed, you're talking about the category description of professional service. So I'm saying is, supposedly if I'm a lawyer, does that mean that I must list every client that I have and what I do for them and stuff like that? Because that seems pretty broad from my thing. If I'm an engineer, I must list every client and what I do for them.
So this is where I wish I had it right in front of me, and I don't. But on that, the categories that are listed in the statute are somewhat generalized categories. I do not know the direct answer to your question, but I do know who to point you to, right? And that's the Ethics Commission staff, which answer that very specific question for you, right? Okay, what kind of professional clients am I have to put down here? Like, and it may be just where under the specific category. However many of your clients fit within a particularized category, you put the number of those clients in that category. I do not think, but like I said, I apologize if I'm wrong, I don't think you're required to list those clients by name at this point. I think it's just a number of them. If there are clients that you have that don't fall into these specific categories, then there's no requirement at all, right, to identify that. That's my understanding of how it works now. Now, part of why I wanted to bring that up was just to say, hey, this was included in the report. We wanted to go over the report and kind of flag the things that the report issued. And if that's something that interests you, we can definitely go back through it, right? And go back through the report. We can go back through. We can either one-on-one or as a part of this committee, whatever the committee decides, right? We can go through it and show you what the form looks like, show you what the law requires, and see what you think about it one way or the other.
Well, definitely so, because what my concern is that we could get so much here that it forces certain folks not to want to even deal with serving in a public capacity, and that's just a concern that I have.
I think that's certainly a valid point, and that's going back to one of the things that we touched on during last meeting is that during the introductory comments about the purposes of the ethics laws, one of those constant tensions in play but is expressly identified by our ethics laws is this tension between wanting to have appropriate safeguards in place, but yet not have too much overreach to where it's an unnecessary impediment to people wanting to serve, in some role in public service. So I think that's exactly what you're kind of headed towards.
Representative Bolton.
Yes, thank you, Jimmy. The question that arose, and this is in another life, I do strategy and consulting for campaigns, and in line with Representative Travis's question, does that include disclosing every candidate that one of us independent consultants receives money from in terms of running a campaign? And also, the question had arisen from outside the committee about how the ethics law should apply to people that provide consultant and strategy services to elected officials.
Yeah, so I asked a question one, again, my recollection, especially whenever I fill out the statement of economic interest, I'm not aware of a political candidate category for professional services. Again, the Ethics Commission staff has always been very responsive to the questions I ask. I'm happy to ask that question for you to get back to you with the next meeting. It's a great question to ask. And to your second question, I think gets into the scope of the entire purpose of this committee is to take a look at consulting agreements paid around. Like, what do you think is relevant and what do you think is unnecessary?
Okay.
So to be continued, I guess, is the answer to the second question.
Hey, Chairman. Chairman, this is Representative Lomax. Had a question for Jimmy real quick.
You have the floor, Representative Lomax.
There you go. All right. So, Jimmy, to me, it seems like all these, have a level of vagueness to them, and they have to be addressed on a kind of a case-by-case basis, which I guess is some of where the issue comes from. Could you either now or later go over using office for personal gain? Because I feel like that one out of any of the others is a little bit of the most vague because it has an element of other people involved. And let me give a quick example here locally. If we have a city councilman who's an insurance agent and somebody says, hey, on Facebook, you guys need to all reach out to Councilman, whoever, for all your insurance needs. He's a great guy. I could view that as, well, he's used his office for personal gain, even though he didn't actually do anything. Or someone could construe it that way. So I didn't know if you could go any further in depth onto that one, or how we're looking at the law currently on that.
Okay, that's a good question. By the way, it's the first time I think it's ever happened where somebody in the voidness, right, called down for a question. It's interesting how that works, experiencing that. But yeah, thank you, Representative Lomax. That's a great question. Use of personal gain, and in your example right there, it is an important question to address. At what point and how much is your role as a public official? And it's not just legislators, right? It's not just councilmen that cast votes. It's public employees as well, right? It's the position, it's teachers, it's firefighters, right? It's all these folks. So how closely connected is the office, and not just your activity, your official activity, but just the position of your office, right? The fact that you hold office. How much does that connect to the activity of obtaining personal gain, right? And we say obtaining personal gain, and I think the majority of the time what we're talking about is how you earn your living, right? How you earn your compensation when we say that. It could be an employer, it could be, your professional service provider. What we're about to get into is, I think it's the last section is where the court touched on the use of personal gain a little bit. I think for right now, I can wait until we touch on that very briefly at the end of this discussion on the open questions from the case. But I will say that might be one of the topics that I spoke with the chairman about maybe taking a deeper dive into further down the road, because it is one of those where it might be worth taking a few extra moments to kind of go in, like, what do we really mean when we say use of office of personal gain? So it's a good question, and not a lot of answer, but we'll touch on a specific, kind of question that the court asked here at the end of this case study.
Any other questions from the committee? All right, let's go.
Okay, so the first topic, again, and a lot of these topics are going to be familiar because of what the ethics laws cover, what the commission report indicated and talked about, and then now there's this case that dealt with a lot of these similar issues. So this particular issue actually was from the Court of Criminal Appeals level of the case. It dealt with the conflicts of interest in general, right? So issue number one, the court left open the question, right, of these two definitions and which one should apply to violations, or both, should both apply, right? There's this big question out here. The specific statutory prohibition in question was this Section 5B issue, where a member of a legislative body may not vote for any legislation in which he or she knows or should have known that he or she has a conflict of interest. I mentioned Section 9 is tied to conflicts of interest, but this is the only section where the term conflict of interest is specifically mentioned. And then we have these two different definitions, right? Touched on earlier. The definition that's in a subsequent subsection of this prohibition in the same statutory section, this 5F, it requires ownership or control of more than of over more than 5% of a business entity, right? Or if you're an officer or director. So it kind of focuses on that control and ownership element, right? Then the general definition that's under the definition section of the Act, requires a unique financial benefit directly to the individual or a family member or to a business with which the person is associated. And as we'll see, as we already know, right, that term, business with which a person is associated, is another definition, another level of analysis that has to be undergone, which there's been questions as to the exact scope of that one too. So the question here, again, number one, which of these should apply or both? Issue number two was the definition or scope of employee. But by the way, let me go back. I'm sorry, I forgot to mention this. Under the conflict of interest, just for the record, the way the court resolved this here in this particular case was they said that they didn't have to get to that level because they said in this particular case, neither one of these definitions was met. And so that's why that's why it's an open question, right? Why it's still out there. It wasn't resolved because under their analysis, neither one of those definitions were met. Issue number two, the definition and scope of employee is not included in the definition of a business with which a person is associated. So here you have three levels of definitions, right? You have conflict of interest, which involves a business with which a person is associated, which involves a definition or the scope or the term employee. And what does that mean, right? So there's three levels here that we're dealing with and trying to come to some type of conclusion, right? So 3625.1.2 is the definition of business with which a person is associated. And as you can see, it includes the term employee, right? But exactly what does that mean under the context? So in this case, the court kind of flagged that as a point of discussion. What constitutes an employee was an important factor in this case, right, when dealing with whether a part-time employment or professional services, consulting agreements, contracts fell under the definition of employee. So the court, recognizing there was not a definition of employee in the statute, they turned to the closest thing within the ethics laws, right, that they could, which was the definition of a public employee. And under the ethics law's definition of a public employee, it expressly excludes part-time employment for professional services other than lobbying, with the qualifier that it has to be less than the 50% of the recipient's income. The court also secondarily referred to Black's Law definition of employee, and Black's Law dictionary is like a common dictionary that courts use because it has a lot of legal definitions and how these definitions of words apply in a legal context. If you see the Black's Law dictionary, that's just a popular use or a popular tool by courts in the legal system. So they turned to that definition of employee, which included a requirement that the employer retains a right to control the details of work performance. So in light of these things, the court determined that part-time employment for professional or non-lobbying services, which did not constitute more than 50% of a recipient's income, was not employment with a business, well, I said in here an associated business because it takes a lot of words to say a business with which the person is associated. And they kind of, and this is my phraseology, right? And especially if the employer does not control the details of the work performance. So, lingering questions from that particular topic, right? Should the conflict of interest provisions be addressed to make clear which definition should apply, or should both apply? Regarding the business with which a person is associated definition, should that be revisited? The scope of employment, should that be kind of clarified? What should fall under that definition? That's kind of the lingering question. I'm not here to say which one is or which one isn't. That's just the question that's left out there on that topic. For the sake of time, I'm going to keep moving into the next section, which is the kind of a topic that was addressed by the court regarding the definition and scope of principle. So the issue here, right, in my phraseology, again, this is how I kind of summarized it, the court's opinion highlighted the lack of definitional clarity for the term principle. This primarily, and not primarily, this really involves the gift ban prohibition that we talked about last session from the report, right? No public official shall solicit or receive a thing of value from a principal. All right, so here that's the general gift ban prohibition. The definition of principle, which of course applies to this prohibition on the gift ban, right, is or the exchanging of things of value, is a person or business which employs, hires, or otherwise retains a lobbyist. So the primary focal point here are individuals within a business also considered principals, where the business employs, hires, or otherwise retains a lobbyist. If so, which one? So, okay, an individual hires, employs, or retains a lobbyist. Okay, got it. But the business, is it the business entity? Is it the corporate name, the corporate entity? Or is it individuals within that company, and if so, to what extent? So that's kind of that was kind of the primary focal point of the discussion here. This is another one of my kind of summaries of some of the language in this case. So who is covered under this definition in accordance with the court's opinion? So my takeaway was it was undisputed that I could see, right, that individual persons and the business entities themselves are principals if they employ or hire lobbyists, right? Assumed without deciding, though. Yes, sir. Yes, sir.
Representative Jackson.
Thank you. Something happened when you just no principle. Now, my mind just took off as it relates to what happened prior to, there was a time when legislators was given tickets to Auburn, Alabama game. Iron Bowl, in other words, and then, other games that whoever wanted to go. Now, something happened in that process, and let me say, it had nothing to do with morality. It had a lot to do with racial content. A few black people was elected. I'm just going to bring it out. And we were showing up in places we shouldn't have been. So this thing happened. We're going to stop it. And that part of it was not broken. But when they added all the other little, and I told them during that special session, see, some people get contributions, elected officials. I always got mostly donations, and there's a great difference. And so this thing was set in a time when there was so much divisiveness had entered into the state. So the more that we can do to eliminate appearance, then more control that we can promote. So it was a bad idea from the beginning, and it was wrong because it was not coming from the heart in a sense. It was coming from the head to make things difficult. And I'm not the only one that think that way, but talking about the principle, and to tell me I got to buy my ticket, then you're going to invite me up to the president's booth. Well, what's the difference? I buy my ticket, and then you invite me to sit up in your booth. Isn't that given? Is that a gift? Question.
I think it could look that it depends, right? It could be any gift, benefit, right?
Yes.
So it's a broad term. I'm just going to do my best to answer the question, right? With the caveat, obviously, that these are questions that are why the chairman, I think, wanted us to bring these up is for you to have these very conversations with the committee. Is what you're thinking of. But yeah, so the question would be whether that falls under an exclusion or not. Could not. Like I said, it's the commission report indicated, and I'm trying my best to keep as much of my opinions or my analysis out in order to focus on the commission report, which is what the committee was focused on. But I think the commission report indicated that some of this stuff is circumstantial, right? Depending on the circumstances. Was there evidence of some type of quid pro quo or something like that happening? And of course, I don't know with your general question.
Representative Jackson, we'll have time to get into the details as we go through. We're just evaluating, getting everybody familiar with where we are.
I just got the question when it came up.
Representative England.
I soon forget.
I think isn't there a specific prohibition against accepting tickets?
There is.
Yeah. You just have to pay face value now.
That's correct.
As where before you didn't. Somebody could give you a ticket.
No, and that's a great clarification. I was focusing on the part of the question about, well, what about being invited up to some type of president's box, right? Something kind of in addition just to a face value ticket. But that's a great point. The ticket thing is something that's expressly included in the statute.
And also, as far as being invited, because I think there was clarification on them being invited to widely attended events for educational purposes, those sorts of things. So
That's
as long as everybody's invited, no special privileges or treatment, and it's for educational purposes and
Diversity of views.
yeah. So I think that's what that analysis kind of plays into that.
That's right. There are several of those, 18 exclusions from the general prohibition that could apply in any given situation. You're exactly right.
Yeah. All right. That's just one.
Okay, so yeah, going back to this this issue about the definition of scope, the scope of principle. In the court's opinion, it seemed to be undisputed, right? Individuals and the corporate entity that does the hiring, right, and the employing. I use the phrase "assume without deciding" because I couldn't find anywhere in the opinion where it actually expressly decided this, but it seemed to me that it was assumed without deciding that an individual within a business that is the signer, right, the one that actually executes the agreements, right, the contractual hiring or employment agreement with the business's lobbyist, that individual within a business would be considered a principal. At issue, for sure, from the court's opinion, was individuals within a business that just simply have influence, management, or authority over the activities of the business, which can include the lobbying activities. So the definitions, express terms, again, a little bit of a repeat, right? Express terms only apply to employing, hiring, or retaining. The former executive director of the commission had testified, however, in this case, that includes kind of this is what kind of, I think, contributed to some of the questions, right, that the court was dealing with, was there was testimony that said in that person's opinion, it not only includes the person that signs the agreements, right, the contracts, but also could include those officers and other decision makers within the business. So in light of that, right, the court was kind of dealt with an issue. Yes, sir.
Representative Woods.
Thank you, Mr. Chair. So this question of principle, it seems to spend a lot of time on that, and in local government, it's pretty clear who's at play. I mean, it's a developer who has a zoning case. It's somebody who has a particular thing so in local. When I was in local government, it was pretty easy to navigate because it's, hey, they've filed something, or I know they're going to file something. You kind of know. I don't have any prior relationship. This seems to be we're kind of struggling with. Who could potentially be influencing us or trying to corruptly influence us? We know a lobbyist could be because they're hired to influence the legislature. But as they chase this rabbit of, well, it's a business who could, or what about somebody in my district who just thinks something should go a certain way or their business might benefit from it? They haven't hired a lobbyist, but hey, here's some tickets. Well, we won't use tickets because we know those are illegal, but here's something. Hey, let me take you out or whatever. I mean, as we try to use that as a proxy, the hiring of a principal as a proxy for somebody, this defines somebody trying to influence. I don't know what the answer is, but it seems like we can spend a lot of time creating confusing and vague red tape on this question when really there's kind of an overarching question of who's influencing, what is something that's before a body. It's easy in a local government. It's easy for an inspector or something. I think legislator, it's a lot harder because we can touch all sorts of things. So I don't know what the answer is, but it seems like maybe the answer to this question is to step back a little more and get more general in what we're looking at than try to define every single possible way somebody could be hiring a lobbyist, doing all these different very specific things. I don't know. This is one of the things that might benefit from being a little more high level. Just my thought on it.
And I said that wrong. Please forgive me. I misspoke. It's Representative Shaw. I apologize.
You're fine, Mr. Chairman. Thank you.
Representative Travis.
Yeah, and I guess the thing that was kind of keep burning me, when we define employee, what about an independent contractor? Because if you're an independent contractor, then you're not in a situation where the company is supposed to be directing their work and stuff like that. How does that apply? Is that something I'm on the road street on?
No, yeah, actually, we're gonna get to that in a few slides. It's a great question. It comes up in the court, in the court's analysis. And yeah, to Representative Shaw's point, so I think it's a valid point that, okay, if you're dealing with a lot of what do you call them, sole proprietors, if you're dealing with companies that are managed really exclusively by a small set of people, it might be one thing, but when you're dealing with bigger corporations that have boards, that have management boards, they have executive committees, they have all different kinds of subcommittees, right? Different parts of different boards that do one thing or another. Those employers hire a lot of people, which means a lot of people are impacted. So I'm not saying yes or no. I'm saying part of the analysis I agree with stepping back is like, okay, well, because I think your original question goes to what the whole purpose of the chair looking over the report was to, like, okay, take a step back and look at where do you see the line of where's the potential danger, right, for corruption? Where do you want to?
What are we trying to do here?
What are you trying to do here, right? Not just for you, but for teachers, for firefighters, right, for municipal employees, for your local clerk, right? Those kinds of folks, all the way up the chain to you guys, to the governor, right, to everybody. So, so anyway, great question. In this matter, so we just kind of talked about, right, does it apply to people in the executive, kind of management level of a company, or is it just the corporation itself, right, or the person that signs off on it? So the court held that the plain meaning, so the statutory text really only had one qualifier, and that was do you hire or employ? Who is hiring, right, or employing a lobbyist? And, they based this decision, right, at least in part, on the fact that, and this is the language from the court's opinion, that the definition unequivocally does not include a person or business that supervises or manages a lobbyist. Corporations also, are separate legal entities under Alabama law from the people or owners or shareholders who make up the corporate entity. So, I guess it might be safe to say that they adopted somewhat of the narrow definition, right? However, they adopted the narrower scope of that, right? It's the corporation and it's the hiring and employing of a lobbyist, but it has a caveat, right? The court mentioned that principals, you aren't solely a principal because of your status, right, as a board member, but you could be if you participate in employing, hiring, or retaining lobbyists under the circumstances of each case. So this is another area where there's circumstantial, facts that would determine whether the application of whether the definition would apply or not. So the lingering questions from this part, right, are going back to Representative Shaw's question. Should additional clarity be added to the definition of principal, right, or not? To better refine it, the court's opinion left open the door to determining what constitutes employing, hiring, or retaining lobbyists to the circumstances of each case. The other issue, which was not adopted by the court, but something certainly for you to consider, is should some type of supervisory or management authority or control over a lobbyist be added to the scope of the definition. So those are kind of the lingering questions that I think spoke to Representative Shaw's questions on this topic. So this one goes into Representative Travis's question, I believe, right? The compensation exclusion, right? So this is another area of the case that the court was dealing with, right? The court noted that their interpretation of the scope of the compensation exclusion might be at odds with perceived public policy. So what do we mean? Like, what is the compensation exclusion? What are we talking about here? So the compensation exclusion is an exception to this, again, the general gift ban, right? The whole ban about not exchanging or soliciting things between lobbyists and principals and public officials and employees and their families, right? So you got this general ban, and this is another one of those 18 exceptions, the compensation exclusion. So as I reiterated, right, you got this 5.1, gift ban. But what about employment or business opportunities with companies that hire lobbyists, right, which are principals, right? Kind of, what about that scenario? So here's the specific compensation exclusion, right? And I've italicized this phrase within this definition, right, within this exclusion that says, as long as there's no quid pro quo, right? So there's kind of an implied, it's not hidden, it's not even implied, it's stated. It's kind of a fourth element that just is at the beginning, right? As long as there's no quid pro quo, a thing of value does not include compensation that's earned from a private, sector employer or business in the ordinary course of business. And then there's this important phrase right here that the court focuses on, most of the analysis is, right? Under circumstances making it clear that the benefits received are for purposes unrelated to the recipient's public service as a public official or employee. Let me just mention one thing right here. So you can, I don't think it's that far of a leap to understand when you use the phrase circumstances making it clear the benefits are unrelated, that circumstances with making it clear is not, obviously it's not the same thing as circumstances that make it clear that it's for nefarious purposes, right? It's circumstances that make it clear that it's not for any prohibited purpose, right? The court's attention, though, was not necessarily on that phrase, but was on the unrelated, as the other word that I bolded here, unrelated. That's where the court's focus was in this particular case. So they adopted a broad interpretation of the phrase that's connected to that unrelated word, right? So their broad interpretation of the phrase unrelated to the recipient's public service as a public official or public employee. So this broad interpretation of the word and the phrase that's connected to the word unrelated resulted in a narrow interpretation of the scope of this exclusion, right? The scope of this compensation exclusion. So the court held that to meet this third element, to not be in violation of this gift ban between principals and, and public officials or employees, that the compensation must be provided solely for reasons unrelated to the person's public service, and that unrelatedness must be clear from the circumstances of the compensation. All right, so then the court issued a warning after this, right, where it said, and basically in light of its interpretation, we recognize, as the court's words, we recognize that this interpretation of the statutory language could result in shutting out from the compensation exclusion some forms of private employment or advertising that might otherwise be assumed innocuous or innocent. To the extent that that result may be in tension with perceived public policy, any remedy lies with the legislature, not the courts. So, in light of that, there's lingering questions, right? Should the statutory language of the compensation exclusion be amended to better align with public policies, purposes? Or does it effectively address the concern, even if you're, like the court said, some of these otherwise innocuous situations just might not be available. So it's just something for y'all to consider. It's one of the issues they brought up. For the sake of time, I'm going to keep going. So another one of these exclusions, we just dealt with a compensation exclusion, right? So now we're dealing with a different exclusion, which is the full value exclusion. The court's opinion highlighted the lack of definitional clarity in the full value exclusion. So again, we're dealing with the same gift ban, right? This 5.1A, no public official shall solicit or receive a thing of value from a principal. So this full value exception to the gift ban is, again, as long as there's no quid pro quo, it's anything for which the recipient pays full value. And we just touched on that a little bit a second ago, right? This full value exception. Okay, so the court's opinion revealed that the statutory language lacked clarity as to whether the word pays could include more than just a payment of money. Again, we have definitions that use terms that may or may not need additional definition or additional clarity. That's what we're dealing with here, is multiple layers, right? So the court held that the term pays could include non-monetary valuable items, such as company stock. Black's Law Dictionary and other research sources found that such sources incorporated non-monetary items into their definitions of payment. The court also reasoned that since this exclusion's broad and encompassing term anything, the term anything could include the receipt of money. If that's the case, then the term pays could reasonably include non-monetary items such as company stock. And if you haven't picked it up by now, right, this was a situation involving an investment into a company, a business with which the person was associated, and in exchange for stock that paid dividends, right? And I think it was like 6%, I think is what if I remember correctly. So does that fall under this full value, pays full value? So that was what the court was dealing with, and they held that it could, right? I have a note down here, the full value. The court went into an analysis on what is full value. That's also something that's not defined in the statute, and the court just went on to establish in that particular case, under those circumstances, there wasn't any evidence that it wasn't full value, basically. But the question's still out there, right? What does that mean? Yes, sir.
Vice Chair Allman?
Yes, thank you. You just alluded to the underlying facts of the case when you were talking about this. If you could do that more often, that would help me a lot. I don't remember much about this case. It's been so long ago, and I wasn't here, so I certainly wasn't paying attention to as much on this level of detail. And I know you're pushed for time, but that helps me a lot if you can give the context of the case.
We'll have another discussion on the context of the case, but for the purpose of today, let's just go through with the issues that you have.
That sounds great. Okay, so full value and also not. It was just done by the court, right? It was addressed by the court, but that could be another area to take a look at, right? So lingering questions. So should additional clarity be added to the term pays, right? The court's opinion expressly included company stock in the definition, but left open the scope of what additional, like once you open the door to non-monetary items, where does that lead to? Is it worth considering putting some additional clarity in there about what it means to be paid? Secondly, should clarity be added to what constitutes full value? Right? Or is it best left to the discretion of the courts under the facts of each case? Just like I said, just questions that are out there. Now we're going to get into the use of office for personal gain, right? So The court again noted there might be a difference between perceived public policy and the statutory language in 5A. 5A says no public official shall use or cause to be used his or her official position to or office to obtain personal gain, this is my parenthetical, including financial gain for family or associated businesses. The main focal point here was that in addition to the use of office to obtain paid contracts or to increase compensation under existing arrangements, does this prohibition also apply to fixed compensation contracts? I guess I'll just mention real quick, so what we mean by fixed compensation contracts is the contract is not related to performance. So, hey, you're going to get paid X amount of dollars for this amount of time for this, to do whatever kind of professional service you've been paid to do, but what we get in return for this service does not affect, under the terms of the existing contract, does not affect what your compensation is. That's what the court meant when it said fixed compensation contracts. So the court held that 5A's prohibition against the use of, of office for personal gain applied not only to, hey, am I using my office, my position to obtain a contract or to obtain a compensation, to increase my compensation under an existing contract or arrangement, or 3, does it also apply to conduct in the performance of a fixed compensation contract? Yes. In this particular case, the court said that it could include that. The court reasoned that the performance was still connected or could be connected to obtaining, what does it mean to obtain gain? They said that it could be connected to obtaining, because what if there's an early termination clause? Could it be terminated if you're not performing to a certain level? What about renewing that contract? Could it be, if you're not performing to satisfactory levels, is that contract going to be renewed? So in the court's analysis, these kind of contracts where you just get paid for, usually it's a year, right? Or so, I say usually, the ones that I deal with, right, are year-long contracts for a set amount, that kind of contract could come under. Now, one of the things that, even if we go into the specific facts, deeper at a different time, I will mention, and you probably know this just as well as I do, Representative Allman, courts, their MO, right? Their MO is to answer questions or resolve cases without going to extraneous stuff as much as possible, right? With answering the fewest questions possible, right? So sometimes this may be one of those areas where the court answered the question in the fewest way, right? The answered the fewest questions in order to get the case resolved without going beyond that. So to me, there was a lot to unpack in this area because the court, and I'm not blaming the court, that's just part of it, and I think there's wisdom in the court's decisions, but it doesn't really help for an ongoing analysis, right? That's what the body's going to have to discuss and kind of go into further. So, and this is where you get my note from, right? The court's opinion did not provide an exhaustive list of what could be considered improper use of position or office for personal gain. The court, the other side of the case had presented some hypothetical scenarios, like, okay, do you really mean the performance of the contract? Like, what does that mean? Exactly what do you mean by no connection between the fact that I'm an office holder, right? The fact that I happen to be in office or an employee, right, a public employee, where's that connection? And do you really mean that? Is that what we really want as a public policy? And the court neither agreed or disagreed with those hypothetical scenarios, and instead just simply referred back to you guys, to the legislature, right, to say, okay, well, hey, look, they basically said we're focusing on the language of the text. If it's inconsistent with the legislature's, public policy positions, then they left it with the legislature to kind of address it. So the lingering question here, my takeaway from that was, should that language in 5A be amended to clarify exactly what are the prohibited areas of conduct in circumstances where compensation under an existing contract is not directly related to performance? That's kind of the lingering question I had, and that's all I had.
Questions from the body, Representative England?
Just a general question. I know it, I can't remember anything off the top of my head right now, but I know from when the decision was rendered up until today, we've done several things along the line to change definitions, to create exceptions, and so forth. So at some point, it would be helpful for us to, where we started, what the opinion created, and also the things that we've done in the interim up until now that have changed some of the things that were in that opinion. So, I mean, that would be great, very helpful. So,
yeah, I think the chairman actually mentioned doing that. So it's you know, it's direct, obviously it's on point because the chairman had mentioned like, hey, let's talk about what we've done. And I'll just briefly say like there's from some advisory opinions that were out there, there was an issue at one point with what does de minimis mean? That wasn't defined. So the legislature ended up defining what de minimis meant, right? There was other changes, like the FCPA was issues were added to the Ethics Commission's jurisdiction. And so those are two things that popped up off the top of my head, but there's several others, and I'll be happy to put together graphs and handouts about what's been done since 2010.
We've created distinctions between what lobbying is versus what economic development
that's right.
is.
HB 317.
You know, we've done several things about who's required to report, who's not, that sort of thing. So those sorts of things also change our responsibilities as public officials too. So it would be very helpful to know what's the differences are now. So
I believe Representative England has, great minds think alike. He has told us what we're going to talk about at our next meeting already. Jimmy Inchkin and I have already talked about the next meeting. We're going to discuss what legislation has been filed since 2010. How did we get here to kind of address some of these topics as we get through? Any other questions from the committee?
I just want to make a statement. Thank you. I know I've been, but I'm glad that we're here, and it's needful that we have ethics laws that'll have some teeth and have a black and white direction of where we're going. You know the do's and the don'ts, but it's not going to change the heart of man. It got to come from within, and it's going to have, you got that greed out there, and people going to think they can push the envelope and keep pushing it. But I'm grateful that we can do something to stop that. Amen.
That was the intent of these last two meetings that we had, to discuss the issues that were brought up through the commission report that was made in March of 2019. We've kind of gone in depth about that, to discuss the issues that the courts have identified as issues that need to be addressed, and we go through. So the messaging was, okay, we realize there's a problem. We realize there's issues that we're going to have to take up, and we have a lot of work ahead of us. But to get everybody on the same page, to get everybody brought up, because not a lot of people were serving on this committee at this time. So to get everybody brought up and up to speed to where we are, how we got to where we are today. The next meeting we're going to discuss legislation that's been filed since 2010 to try to address some of these issues, to address the topics, to address where we are. That meeting is going to be October the 26th, 2023 at 11 a.m. That is going to be, it's a Tuesday, not a Wednesday next time. I think we had some staff issues that we had some staffing going on within the State House that have some events that the 27th. So Tuesday, no, we're good. It's a Thursday?
Thursday.
Oh, I'm sorry. It's a Thursday, October 26th. So there we go. Thursday, October 26th. We can't do Wednesday. We had talked to everyone last time about 11 a.m. being a good time because everybody could drive in and drive out, get up through here to get through. Everybody's still good with 11 a.m.?
Made it this time, Mr. Chairman.
As long as you provide lunch if we go.
The Ethics Commission does not provide lunch. The Ethics Committee does not provide lunch. Thank you guys for understanding this topic and getting into, you guys get into the weeds of where we are. This is a working committee. We've talked about being a working committee. We have a lot of work ahead of us, and now we're going to start to figure out how do we get out of these problems that we're facing now today. So with that, Mr. Intrican, thank you. Tremendous job.
No problem.
Thank you for your efforts today. That is, and we are adjourned. And we are adjourned. And we are adjourned.